Dear viewers, welcome to the course on property law. I, Dr. Vijeta Singh from SS Mania Law College, Jalgaon, Maharashtra. Today we are going to discuss an important topic, that is termination of lease. So, let us start with the introduction. Termination of lease means termination. The net result is the lease comes to an end. After determination of lease, the legal relation between the lessor and lessee comes to an end. Termination is also called determination. The determination of a lease or a tenancy has to be in accordance with the provision of section 111 by giving notice to quit. Tenant disposed illegally is entitled to recover possession. Under this section, a lease or tenancy may come to an end in the following ways. It should, however, be noted that the effect of this section has been practically superseded by various Rent Control and Evictions Act passed by the various state legislations. First, by efflux or lapse of time. Next, by happening of a specified event. By termination of lessor's interest. By merger. By express surrender. By implied surrender, by forfeiture and by expiry of notice to quit. Let us have the broad discussion over all these terms. By efflux or lapse of time, lease of immovable property comes to an end when the time for which it was made expires. This is called termination by efflux of time, and such a lease for a term requires no notice to quit at the end of the term or any other formality. Landlord has a right to ask ejectment by simple demand for possession and no legal notice is necessary. If the premise remain in the possession of the tenant or subtenant after the termination of the tenancy or lease, then there is an obligation to pay means profit. A lease is a transfer of an estate and it does not terminate with the death of the original lessee, but survives during the remaining term of his heirs and representatives. For lease are heritable, where the lease is with an option of renewal, but not exercised before the expiry of the lease. It is held is determinable on the expiry of the term of the lease, and leasee can be ejected but not before the expiry of the period of lease, where the agreement of renewal required fulfillment of two conditions: exercise of option of renewal by the leasee before expiry of the original term and fixation of the term of a new lease by mutual consent and in its absence through mediation. The lessee remained in possession without complying with the requirements. The court said that the lessee was not entitled to remain in the perpetuity either as a tenant or a lessee by holding over. He had to comply with the requirements of renewal. Having not done so, he was neither a tenant nor a lessee. Normally, a covenant for renewal is a one-time affair and not a perpetual. Such a renewal is a new lease. It is called a renewal because it is assumed the existence of prior lease. A covenant for renewal runs with the land. Hence, lessor, lessee and their successors are bound by them. Determination of lease by efflux of time takes place when duration of lease is fixed by a valid lease deed. If the lease deed is not registered, which ought to have been registered for its validity, such a lease cannot be terminated by efflux of time. Determination of lease by efflux of time takes place when duration of lease is fixed by a valid lease deed. If the lease deed is not registered, which ought to have been registered for its validity, such a lease cannot be terminated by efflux of a time. By happening of a specified event, clause B, where the term of the lease depends upon the happening of a specified event, the lease terminates upon the happening of that event. Thus, a lease for lifetime of the lessee terminates on the death of the lessee. In other words, where time is limited conditionally to the happening of some event, determination takes place on the happening of such future event. So long as the specified event does not happen, the lease continues. For instance, where a lease is made for a term of 40 years or upon the death of the lessee, whichever is earlier, the lease shall come to an end if lessee dies before expiry of 40 years. A lease for the duration of war comes to an end upon declaration of peace. Termination of lessor's interest, clause C. This clause operates where the lessor has only a limited interest. For example, when a Hindu widow have only a widow's estate, grants a lease without legal necessity, on her death, the lease is also determined. Similarly, a lease by a usufructuary mortgage can be determined by the mortgagor exercising his right to determine on redemption. In other words, when a mortgage is in possession grants a lease, it is only extend up to the term of the mortgage, but it does not automatically end. In such a case, the mortgagor has a right to terminate the lease. But where a lease from year to year was granted by the mortgagor of a temple, in the course of management, the Apex Court held that the lease does not come to an end with the expiry of the office of the management or his successor. Where a lease sublets the property, the sublease comes to an end upon the death of the lessee. In the renewal of a lease, there exists an inefficacy of a renewal of sublease during subsistence of renewal of original lease. A sublease is stopped from denying the title of the landlord so long as he actually or ostensibly enjoys the possession under the lease created by such landlord and must deliver possession back to him even where the original lease had expired. By merger, clause D. According to clause D, where the interest of the lessor and the lessee becomes limited in the same person at the same time in the same right, there is a merger and the lease is extinguished. Merger takes place when tenant himself becomes the absolute owner of the tenanted premises. Thus, merger means meeting of one interest with the another interest. When limited interest becomes absolute interest, there is a merger because smaller interest merges with the larger interest. Where the landlord makes a gift of or sells the tenanted premises to the tenant, the latent does not remain a tenant. He becomes owner of the premises. The tenancy is therefore determined by the merger of a reversioner with the tenant's mere right of enjoyment. Section 111 clause D embodies the principle of the maxim nemo potestas tenens et dominus. This means nobody can be both landlord and tenant of the same property. Where the interest of co-owner is required by the lessee before expiry of the term, the lease is determined and the lessee becomes owner of the premises. For merger, it is necessary that there is a union of two unequal interests at the same time in the same person. It is also necessary for merger that there is a complete fusion of the interest of both the lessor and the lessee. Thus, if the lessor purchase the lessee's interest, the lease is extinguished as the person cannot at the same time be both landlord and tenant, but there is a no complete union of fusion of the interest of the lessor. The lessee, there is a no extinguish of the lease. Therefore, there will be the determination of lease where the leasee purchases only a part of reversion, where all the rights and interest in the lease held property become vested in the leasee by virtue of an action cell with of confirmation of the court. It was held that all proceedings and decrees and orders passed in such proceedings become null and void. Next, by express surrender clause E. Surrender is the opposite of merger. In a merger, the tenant acquires the reversion, whereas in the surrender, the landlord acquires the lease. Surrender means to give up in favor of or for the sake of another, to give up something out one's own possession or a power into that of another who has or assent to a claim to it. In simple language, surrender is giving up the term of lessee's interest to him who has the immediate reversion or the lesser's interest. Surrender consists in yielding up of the term of the lease accompanied by delivery of possession. Delivery of possession is essential unless there is an agreement to surrender at some time in future. Surrender may be oral, but it must be accompanied by delivery of possession. Surrender without delivery of possession is ineffectual. When the original lease is registered, surrender of any part of it must also be by registered instrument. Surrender in law is the yield up by the leasee of the interest in the lease, and it thereby brings extinction on the lease, so that the relationship of the parties to the lease thereafter comes to an end. There is no subsisting interest of the leasee on its extinguishment to surrender, which may devolve or come on the lessor. Thus, an express surrender of the lease brings it to an end before the stipulated time. Surrender can be only with respect to the whole of the interest and not a part of it. A deed of surrender does not require a specific form or registration. Delivery of possession is not necessary where the parties surrender the tenancy and substitute it by fresh agreement. By implied surrender clause F. Section 111 clause F of the Transfer of Property Act, a lease of immovable property can also come to an end by an implied surrender. Implied surrender is also known as a surrender by operation of law. In English law, delivery of possession by the tenant to a landlord and his acceptance of a possession affects surrender by operation of law. Under Indian law, an implied surrender may take effect either by creation of a new relationship or by relinquishment of possession. So, let us see creation of new relationship. An implied surrender can be presumed from the conduct of the parties. Suppose a leasee before the expiry of a term enters into a new lease, then there is an implied surrender of the old one. The underlying principle behind clause F is that when a certain relationship existed between two persons in respect of a subject matter and a new relationship has come into existence regarding the same subject matter, the two sets cannot coexist, being inconsistent and incompatible with each other. That is, if the latter can come into effect only on the termination of the former, then it would be deemed to have been terminated in order to enable the latter to operate. Where the new lease is void or voidable, as for example, new lease does not pass an interest according to the contract or intention of the parties, the acceptance of it will not operate as implied surrender of the former lease. Next is by relinquishment of possession. In case of relinquishment of a possession, although technically a tenant may continue to occupy the premises. Once the nature of possession changes resulting in a change in his status with his acceptance, it amounts to a virtually taking over of possession. Thus, relinquishment of a possession give rise to implied surrender if the lessee surrenders the same and lessor accept it. Relinquishment of possession operates as an implied surrender when, after a dispute as to rent, the lessee returns the keys to the lessor who accepts them, or even if after initial refusal to accept the keys, his conduct shows that he has exercised his option to accept the surrender. In other words, taking of possession by lessor need not necessarily be physical taking, but something amounting to virtual taking of possession. If the keys of the premises are handed over, surrender takes place. Mere abandonment of a possession by the lessee does not amount to surrender. The abandonment must be accompanied with acceptance of surrender on the part of the landlord will suffice. When tenancy is surrendered and substituted by a fresh agreement, then even if there is no physical handing over of the possession, it is of no consequences. But if the lessor enters into possession over the premises under his right or forfeiture held, the consent of the lessee for such re-entry does not amount to surrender. By forfeiture clause G, another mode by which a lease is determined is a forfeiture. Forfeiture of a lease means loss of lessee's right to use the property by some omission on his part. Under this clause, a lease of immovable property determines by forfeiture in the following circumstances. First, if the lessee breaks an express condition which provides that on breach thereof the lessor may re-enter, or second, if the lessee renounces his character as such by setting up a title in third person or by claiming title in himself, or if the lessee is adjudged as insolvent and the lessee provides that the lessor may re-enter on the happening of such event, a lease of an immovable property would stand determined by forfeiture if any of these cases mentioned above thereof is fulfilled, and it is obligatory on the lessor or his transferee to give notice in writing to the lessee of his intention to determine the lease. Lease of immovable property is determined under section 111 clause G of the Transfer of Property Act because the lessee by his own conduct, express or implied, invited an event upon which the lessor got a right to determine the lease even before its expiry. It contemplates three contingents on the happening of which the lessor may re-enter in all the three cases. The subsection provides that the lessor or his transferee should give notice in writing to the lessee of his intention to determine the lease. Though the notice need not be in accordance with section 106, a notice in writing to the lessee of his intention to determine the lease on one of the three grounds mentioned in section 111 clause G is necessary. It may be noted that a notice terminating the lease enormously making a mention of a wrong provision, that is of section 111 clause G instead of section 111 clause H, would be exclude the jurisdiction of a rent tribunal to entertain petition. Each of the three circumstances of forfeiture outlined above is briefly discussed below. Breach of express condition. When the lessor imposes upon the lessee any express condition and lessee fails to perform that condition, there is a breach of condition by lessee. The lessee's right under the lease is not upon breach of such condition. For determination of lease by forfeiture, two elements is necessary: express condition laid down by lessor and the lessor's right to resume possession upon the breach of condition. The condition must be expressly stated as so to become part of the stipulation between the parties. It must be laid down in the definite terms that lessee must do or abstain from doing a thing during the lease. The law regarding termination of leases by forfeiture, the Apex Court held that a condition restraining lessee from alienating leasehold property is not illegal or void, and that in this regard no distinction has been made between perpetual and temporary lease. But such conditions alone is not sufficient. There must also be provision that on breach of condition the lessor is entitled to re-entry, that is, take back the possession. In the absence of a right of re-entry, there cannot be determination of lease by forfeiture. Express condition in the lease may be of regarding payment of rent on a specific date, or for not alienating the property, or for using the property only in the particular way, etc. Denial of landlord's title. Lessee has only a limited right in respect of the tenanted property. He is not owner. When the lessee claims to be owner of the tenanted property, he denies the status of landlord, but by so doing he also denies his own status of tenant. First, insolvency of lessee. Insolvency of lessee by itself does not forfeit the lease. There must be a stipulation between the parties that lessee's right shall be lost in case of his insolvency, and the lessor would be entitled to resume possession. Reason behind providing for condition of forfeiture of lease upon lessee's becoming insolvent is to ensure regular payment of a rent by lease. Let us see the conclusion. The above mentioned cases, there is a forfeiture, but the lease is not determined ipso facto. When the lessee commits any lapse on his part, the lessor gets right to forfeit the lease before expiry of the term, but for determination of lease, written notice by the lessor must be given into the lessee. Thank you.